Everyone. Good morning. My name is Bill Purcell, and I'm coming to you from the offices of the Greater Valley Chamber of Commerce, where I serve as your devoted president. The sun is coming out. It's going to be a beautiful spring day, so I hope each of you will get out and enjoy it. Today, we're revisiting a subject that we touched on earlier this year with our partners from Bridgeport Regional Business Council. And it is everything there is to know about Connecticut paid leave, but you were afraid to ask. So we're going to be answering questions like which employers must participate, who will be eligible for paid leave, and what resources are available to support both businesses and employers. And I have the distinct pleasure of introducing our special guest. But before I do introduce Andrea, I want to thank my friend Walter Murphy, Managing Partner of I Benefits and Chairman of the Chamber's Ambassadors Committee, for conceiving of this morning's program, as well as the one that we did several months ago. So Walter, if you're out there, just thank you very, very much for your support. So I do have the distinct honor and pleasure of introducing Andrea Barton-Reeves, who's the Chief Executive Officer of the relatively newly created Paid Family and Medical Leave Insurance Authority. And we were chatting before. Andrea began her duties on March 2nd of 2020. So she's a year and counting now into her second year. So congratulations, Andrea. So let me just give a short bio of Andrea, if I could. Andrea, prior to being named the commissioner, she served as president and CEO of a nonprofit called HARC Inc., a provider of services for people with intellectual and related disabilities. Before joining HARC, Andrea served as Director of Program Operations at Lawyers for Children America, Inc., and she enjoyed a 10-year career in the insurance industry at Chubb. She's also been very active in the community. Thank you for that, Andrea. She was president of the Connecticut Bar Foundation, board chair of the Village for Families and Children, and director of Leadership Greater Hartford. And we have our own Leadership Greater Valley program here as well. So I know what you do up in the Hartford area. Andrea is a graduate of Rutgers University and earned her law degree at the New York Law School. She, like me, we were talking, she works with a board of directors, a very distinguished board of 15 members, which is chaired by Josh Gabal, the Commissioner of the Department of Administrative Services. So Andrea, thank you for joining us this morning. We look forward to your presentation, and we will be recording this and adding it to our library of resources for business going forward. So Andrea, the floor or the screen is yours, I should say.
Thank you very much for that very kind introduction, and welcome everyone. I appreciate you taking the time to be here today. I know we're very busy and somewhat fatigued by sitting in front of screens, but I will do my best to go through this presentation, and then we'll have an opportunity to answer questions afterwards. So what I'm going to do now is share my screen. And let's see.
We can see your screen, Andrea.
Thank you very much. I'm going to turn off my video so I'm not a distraction. And just one more change. Okay, and I'm going to start this from the beginning. And off we go. So I will apologize in advance for some of the background noise. One of my neighbors is apparently having their entire house renovated today. So it's a little noisy, but I do have the window closed, so it's still pretty loud. But so I apologize if you can hear that construction noise in the back. Today, we'll talk about the paid leave program, some of the timelines and the updates that you should be aware of. I'll give a brief overview of the leave laws and what responsibilities employers have in administering the Connecticut Family and Medical Leave law itself and the paid leave program. We'll speak a bit about employer and job protected leave and how that intersects with income replacement benefits. Then we'll speak about the authority's responsibility for income replacement benefits, direct you to some additional resources that you might need, and then we'll open up the floor for questions and answers. So just a bit about the Paid Leave Authority. Our mission is to provide pathways to accessible paid leave benefits. And we do that by empowering employers and administrators and healthcare providers by offering you tools and training and other kinds of support so that you're able to navigate the paid leave program. We have 5 primary responsibilities at the authority, and they include outreach and engagement. So again, we thank you for the opportunity to be here. We develop policies and procedures that are needed to administer the program. We are responsible for establishing the trust fund contribution rate, which cannot exceed 0.5% by statute. We audit and approve private plans, and we administer the claims for the paid leave benefits. And those claims will start to be accepted, hopefully in December, and available starting in January of 2022. A few key dates that you should be aware of. Employers were asked to register with the paid leave program starting in last November. And now, since that time, we have had employers withholding 0.5% from employee wages. And in late January, we had employers begin to accept private plan applications, submit their private plan applications. And then those applications, in fact, could you hold on one moment for me? Again, now there's just more.
Please bear with us for just a moment while we have some technical difficulties here.
I appreciate your patience. So I hope I am back. So the noise got even louder before and I was able to hear you. So on March 31st, the contributions to the Pay Leave Authority are due with a 30-day grace period. So that's only a few days from now. And we do have many employers who have been withholding and remitting their payments to the Pay Leave Authority. So we really want to thank you for your cooperation and your support. The key dates that also you should be aware of include a catch-up period. So we know that there are a number of employers who maybe have just become aware of the law itself or their obligation to participate in the paid leave program by withholding the 0.5%. So for those employers that did not know that they had this obligation or had not begun to withhold, they do have until the paycheck that ends June 30th to take an additional 1% from employees' pay to make up for those contributions that should have begun in January of this year. If that is still not a sufficient amount to be withheld in order to contribute to the fund, then you can contact the Paid Leave Authority and we can work with you on a case-by-case basis for an extension so that you can make up those contributions and bring all of your employee contributions up to date. Quarterly contributions are due now in July, October, and in January of next year. Those reflect the 30-day grace periods after the end of the quarter. Starting in December of 2021, contributing employees, sole proprietors, and self-employed individuals can begin submitting their applications for benefits. That is in fact our plan, and that benefits should then become available in January of 2022. My slide to advance, here we go. Okay, so here are some important updates. We have selected a vendor to work with us for claims administration, and we are currently working on the contract. I know there has been a lot of thought and a lot of speculation around it. Well, exactly how will the Paid Leave Authority administer claims for the thousands and thousands of people who will be submitting them? We will not be doing this internally. We have selected a preferred vendor, and once we're able to make that announcement, we will. Information regarding that vendor is underway, and information regarding claims administration and how that process will work is under development. I have to say, we've been working on this for quite some time. We're actually now working on operationalizing what we have already determined the process should be based on our experiences in other sectors and in what other states have shared with us as their best practices for claims administration. We are also collaborating with the Department of Labor in order to develop information regarding changes to the family medical leave law. So what a lot of small businesses might not be aware of, because they were fewer than 50 people or fewer than 75 people, is that the state already has a Family and Medical Leave Act, that has been in place since the early 1990s. So that law will change. And now there will be an opportunity for people to take that leave with wage replacement. So those are really the differences. Some things that you need to know. The Connecticut paid leave law, created the authority, and it establishes a source of income replacement for those who take leave for qualifying reasons under the statute. The authority does not provide job protection. So that means if a person has not worked long enough for their employer, but they are otherwise eligible to take leave, they do so knowing that they may not have their job to come back to. So we're really encouraging people to have those conversations with their employers before they choose to take their leave. Second, and this is what I just mentioned earlier, the Connecticut law regarding job protection is changing. And I'll review that in another slide in a moment. The contributions for the first quarter are due now, and we do offer tutorials on how to make those payments, and you can find them in English and Spanish on our YouTube channel if you'd follow these links, and we will make this presentation available for your reference later. And then some of the questions that we get very frequently include this one. So what number should employers use to deduct that 0.5%? You should use the same guidelines you would use for Social Security, which is essentially FICA, which on most W-2s is in box number 3. So your 0.5% deduction is based on FICA wages. All right, overview of the leave laws. Let's start by talking about who's covered by the Connecticut the Connecticut Paid Family and Medical Leave Law. I'm ahead of myself in talking about the Employment Act. Those employers who are covered are those that have one or more employees working in the state, and that does include nonprofits and private sector employers that have a unionized workforce. Those who are sole proprietors or self-employed individuals may choose to opt into the program, but if they do so, they have to remain in for a minimum of 3 years. Employers who are not covered by the plan include those that work for the federal government, some state of Connecticut employees, except those that are considered covered public employees. And the same is true for those who work for municipalities or local or regional boards of education, unless they too have covered public employees. The sole exception are those that work in non-public elementary or secondary schools, often known as independent or private schools, because independent and private schools have traditionally not participated in family and medical leave in the state of Connecticut. A covered public employee, I don't have that slide here, is an employee that is not in the union. So that means that those that are participating, let me say it a different way. Those that are participating in the plan are those who are not in any union in the state of Connecticut. The covered public employees are unionized employees who vote to participate in the plan for the state of Connecticut. With respect to municipalities or local or regional boards of education, those covered public employees are also unionized employees. The difference here is that if a person works for a municipality and they're in a union, or they work for a local or regional board of education and they're in a union, if their unions vote to participate in the paid leave program, then everyone who works at the municipality and everyone who works at the local or regional board of education, respectively, are then included in the paid leave program, whether they are in the union or not. So that's an important distinction. That does not apply to, the same rule does not apply to that state of Connecticut. That's only for municipalities or local or regional boards of education. So let's go on a little bit to the overview, excuse me, of the leave laws. As I mentioned before, there is federal family and medical leave, which has also existed since the mid-90s. There's Connecticut family and medical leave, also has been in place for a very long time, but it has only applied to employers with 75 or more employees. There are other laws that provide job protected leave, meaning that a person is entitled to either keep their job or a substantially similar job if they return or need to take leave under these laws. And that includes workers' compensation, the Americans with Disabilities Act, the Pregnancy Disability Act, and the Connecticut Fair Employment Practice Act, which was the law I had referred to prematurely in the previous slide. These laws will continue to exist. Federal FMLA will be there. It will remain unpaid unless something changes. And we know that there is a move afoot at the federal level for there also to be paid family and medical leave at the federal level. Our law will change in next year, so it will apply to one or more employees. The rest of the laws that are listed here will remain as they are with respect to the threshold level of applicability and their standing as a viable law. Starting in January of 2022, employees will then be able to take their family and medical leave and then also access leave benefits with respect to income replacement next year. And workers' compensation remains an option for those that are injured at work, knowing that a person who is accepting workers, who is on workers' compensation, may not receive paid leave benefits at the same time. Reasons for paid leave or leave under the Family and Medical Leave Act, regardless of whether or not it's paid, are these. You can take leave to create or expand your family through birth, adoption, or foster care. You can take what's known as caregiver leave to care for someone with a serious health condition or your own serious health condition, which does specifically include acting as an organ or bone marrow donor or pregnancy. Special leave can be had to take care of a family member that has been injured during active duty, known as military caregiver leave. And there's also qualifying exigency leave, so that when a person is called up overseas to active duty, they may take time to put their affairs in order and maybe arrange for childcare and put their finances in order for the time that they will be away. What is unique to Connecticut is that this law also allows for up to 12 days of family violence leave under the state's currently existing Family Violence Leave Act. So what does caregiver leave look like? So under the Connecticut law, caregiver leave will be available for the care of these particular individuals. So an employee may be able to take time off to care for a parent, a spouse, a son or a daughter of any age. And this is significant because the law as it currently exists when we sit here today for both state and federal limits this leave for children under 18, or if they're over 18, leave can only be taken if that child has a documented disability. That restriction for Connecticut's law will change next year. You may also be able to take leave to care for a sibling, a grandparent, or a grandchild. Those are categories of leave that do not exist now. Or an individual who is related to the employee by blood or affinity, who has a close association that is equivalent to these relationships that are listed here on this slide. And related by affinity means just that. It is a person with whom the employee has a significant personal bond that's like family, listed in the statute, regardless of their biological or legal relationship. The circumstance under which, with which most people would be familiar is that of perhaps a couple that is living together, but is not legally married. That couple may have been living together for quite some time. One may need to take time off to care for the other. Under current law, that is not permissible under family and medical leave. When the law changes next year, that will no longer be the case as long as that person can provide appropriate documentation that that relationship exists. That could be the person's named as a beneficiary. They may have other types of documentation to show that they own property together. There are different ways that they can demonstrate a familial spouse-like relationship. What are the eligibility requirements for paid leave and job protected leave? As I mentioned earlier, a person may be eligible for paid leave even though they haven't worked with an employer long enough to have job protection. Starting next year, a person who takes family and medical leave under Connecticut's law is entitled to have their job back or a substantially equivalent job, meaning same rank, same pay, same hours, if they have been employed by that employer for at least 3 months altogether. And there is no hours worked requirement. And so what am I comparing this to? I'm comparing it to our current law, which requires the employee to work for the employer for a year and requires them to work 1,200 hours before they can access family and medical leave benefits. And the amount of time that they have to take off and what they can use is determined by the employer with appropriate documentation. Now, the job protected leave is something that the employer determines based on how long the person has worked with them. The paid leave authority we determine whether or not that person is eligible for paid leave benefits. And they have to meet these current criteria. They have to have earned at least $2,325 in the highest earning quarter of the first 4 of the 5 past quarters immediately before the time they apply for leave. And that can be earned by more than one employer. They also have to have, what's not listed here, is a qualifying reason for leave, and they must not have already exhausted any paid leave benefits to which they may be entitled. Then they also have to be currently working or employed in the state, or they were working in the past 12 weeks before they apply for benefits. Person who is a sole proprietor or a self-employed individual who has opted into the program can also apply for their paid leave benefits. And again, the determination for eligibility for paid leave is made by the paid leave authority. The lengths of leave are these. They are the same whether it is a job protected leave for which the person may not receive paid leave benefits, or if they are accessing their paid leave benefits from the authority. It is 12 weeks in a 12-month period for all of the reasons for leave, except military caregiver leave. A person that is serving as a caregiver for a person who's injured during active duty may take up to 26 weeks of leave in a 12-month period, with 12 of those weeks being paid. 12 days are available in a calendar year for family violence leave, and an additional 2 weeks of leave may be available for any incapacitation that is experienced by a woman during her pregnancy. As an employer, what are your responsibilities in connection with the Connecticut Family Medical Leave Law? Right now, you have a responsibility to register your business at ctpaidleave.org, to calculate your employees' contributions and remit those contributions on a quarterly basis. After this year, once you've done that, those obligations remain. If you haven't registered, you only need to register once. That's a one-time thing, but you'll continue to collect the contributions and remit them. Then after next year, please respond to our request to confirm any employee absences and employee-provided PTO. And here's why this is important. There are some employers that require by their own policies to have their employees use their time before they can access any other benefit. And many employers do this to avoid what is known as stacking, which is having employees save up buckets of time that they can use consecutively to be out of work for extended periods of time. In order to avoid the stacking, employers often require employees to use any accrued time that they have to cover absences, including family and medical leave absences, and then access any other benefits after they've exhausted that. The important thing to know here is that when the law changes in 2022, employers will still be able to require employees to use their accrued time to cover all or part of the time they are away on family and medical leave, but they must allow them to keep up to 2 weeks of their time. They cannot require employees to exhaust all of their time. Now, in connection with Connecticut Family and Medical Leave, we are developing a policy, what employers should do. I'm ahead of myself. What employers should do in connection with family and medical leave is that, develop a policy and forms. That's what we will be doing. We will be sending a form or providing a form on our website that we recommend that employers use when a person is requesting family and medical leave. But we know that if you would like to do that in advance, the Department of Labor and the United States Department of Labor have good resources if you prefer to use your own. But we want to develop one for you. You should also let your employees know about your policy or any policy changes that you think you'll be making. So if you will, be requiring employees to use their time, that now is a good time to let them know that, and now is a good time to confer with either your labor counsel or your HR benefits person about how you might be making those changes. So after next year, you will be processing those leave requests by just confirming the reason for leave, which are the ones that are listed on the previous slide, and determining whether or not the person has been with you for 3 months and has job protected leave, and then track their leave usage. We will also be doing this at the Paid Leave Authority, but we will be doing it from the perspective of the person's eligibility for leave and how much time they're requesting and how much time they're taking off, with constant communication with the employer. A bit about the registration process. It is something that you can find when you immediately get onto the website, ctpaidleave.org. You can create an account, and there's a step-by-step process to show you how to do that. And then once you've done that, you would register your business, and there is actually a checklist here. You choose the tab that applies to your company and just walk through the process. It does not take more than 10 minutes or so. It's really very fast and very easy. If you're not sure what to do, there's also a video that will walk you through the registration process step by step. So let me talk a little bit about how we manage the contributions. They are post-tax, and they are based on the wages as you already calculate those wages for FICA. As I mentioned earlier, businesses have up until the end of the second quarter, that's June, to retroactively collect from those employees if you've not already started your contributions. Contributions are capped at the Social Security contribution limit, and that is for combined earnings at all employers at $142,800, which is now the current Social Security cap. So employers, as we noted earlier, should be remitting their payments no later than the last day of the month following the quarter. And you can do that through the ctpayleave.org site. Once you have registered, you will receive a login and password, and that's what you'll use to go into what's known as My Account, and you'll be able to submit your payments. Once you're signed in, you just put in the amount of your total subject earnings, and then it will calculate the contribution amount for you, and then that is the amount that you will pay. If you are supported by a third-party administrator, they will be filing the contributions and remitting those on your behalf. A little bit about the process for applying to the employer for job protected leave. An employee still has to notify their employee when they need time off from work, and if it's related to family and medical leave. The statute requires that they provide 30 days notice in advance where the need for leave is foreseeable. And if not, then as soon as practicable. So what would that mean practically? It would mean, let's say that a person was in an accident and they were in a coma, they were so badly injured that they couldn't communicate with their employer, and maybe they weren't able to do that. So the most the most practical time they could have reached you was when they were able to communicate. And that might be a few days up to a couple of weeks after they actually would have needed time off to recover from their injuries. The employer then tells the employee whether or not they are eligible for Connecticut family and medical leave, knowing that they fall under those reasons that I noted earlier. And then they need to let the employee, if they need to let the employee know if they need any additional documentation to demonstrate that they are eligible for FMLA. The employer, under law, and this is state and federal, you have 2 business days to notify the employee of their eligibility. This is not the same thing as approving them for their leave. So what you're doing when the employee comes to you with their appropriate documentation is you're telling them that they have a reason for leave that's covered under the statute, that they've worked with you enough time to be eligible for it, and that they then, in fact, can apply. So it's not the same thing as a leave approval. Then the employee provides you with any other documentation that you might need. And they have 15 days in which to do that. And that is primarily what's known as a med cert or medical certification, any other kinds of documents that might be listed here. And so what happens then is that the employee comes to you, let's use what we can call the happy path. They have 30 days advance notice, and they come to you and they say, I need leave. Okay. You determine they're an employee, they have a reasons covered under the statute, they worked with you long enough. Okay, you're eligible to apply for leave. Bring me something that proves that you actually have a medical condition. They have 15 days in which to do that. If they have trouble doing that, then you can give them another 15 days. After that, you can deny their application for family and medical leave and give them the opportunity to reapply. Excuse me. So applying for to the employer for job protected leave, let's just talk about that a little bit more. You have 2 days to let the employee know once you've received their documentation supporting their leave request, whether or not you approve it. And then you have to let them know if they are required to use any of their time, keeping in mind that you have to allow them to keep the 2 weeks, when and how they need to report in, and whether or not they have to prove that they're fit for returning to work before you allow them to do so. And this is very new for smaller employers who've never had to do this before, but it's a common practice. It's already happening for federal and state FMLA. And we at the Paid Leave Authority will be offering a lot more training for businesses who are unfamiliar with family and medical leave, so we can make sure that you have some comfort in how to do this. Then the employee reports to the employer when they actually take their leave, and the employer is making sure that the employee does not exceed that 12-week period and 12-week time in a 12-month period. But don't forget to consider whether or not an employee may be eligible for job protection under different laws. So they may just be eligible for Connecticut Family and Medical Leave alone, or they may be, as I noted in the earlier slide, eligible for job protected leave that might not include wage replacement, and that would be the Americans with Disabilities Act, or the Pregnancy Disability Act, or the Connecticut Fair Employment Practices Act, or they may just not have any job protection at all. They just might just be out of work and there's no job protection and there's no wage replacement. They're just out. And that might mean that there might be an adverse employment decision made after that, but that's up to the individual. So now what happens with respect to an employee's eligibility for income replacement, and what role does the employer play? An employer can require the employee to use their sick, vacation, or other accruals, but as I mentioned earlier, they have to let their employees hold on for 2 weeks. Generally, if there are short-term or long-term disability policies that are available, those sometimes require that state benefits be utilized before they can access their short or long-term disability policies, and that's fine, but we will be in communication with the employer to determine what the employer's policy is with respect to using time that the employees already accrued, and what the short or long-term disability policies might be as we calculate benefits. Benefits can never exceed 100%, even if they're combined with employer-provided benefits. Workers' compensation and paid leave cannot coexist. They cannot be received at the same time. And as I mentioned earlier, employee may be eligible to receive benefits, meaning they've earned a 2325, they've worked for 12 weeks, they have a qualifying reason, and they haven't exhausted their time, but they may not have worked with the employer for 12 weeks, for the 3 months, so they may not have job protection. If you're an employer that has a private plan, then all of this falls on you as the employer. We are, at the Paid Leave Authority, we approve the private plan, but the administration lies with the employer themselves. All right, so how does an employee apply for their paid leave benefits? They start by coming to the Paid Leave Authority. They do not ask employers for paid leave benefits. We validate the reasons for leave and and whether or not the employee actually is covered under the law because of all the earnings that they should have earned from multiple employers. We calculate the benefit amount. We get in touch with the employer to make sure that you know that they'll be away, and to validate their absences, and to see if your policy requires them to use any time before they access any other type of benefit. And then we issue benefits payments. Formula looks like this. If a person earns less than or equal to the minimum wage multiplied by 40, they get 95% of their base weekly earnings. If they earn more than that, they do get the $480, 40 times the current minimum wage of $12, plus the difference between what they earn and the 480 times 60% of that. So that is a quick way that the formula works. It sounds convoluted. It is. We have examples of it on our website, which leads me to the next point here. So our website is ctpaidleave.org, and it has an abundance of information, including a clearer explanation of the very convoluted formula in the statute. You can share information with your employees through using this employee rights poster, a rack card, which is a smaller version of the poster, or the employee fact sheet, which are really 3 versions of the same information designed in different ways, because we've learned that people take in information differently. There are also videos available in English and Spanish that cover the same data that's in each of these documents. If you have not yet begun taking out any money from anyone's paycheck and you need to explain that, this employee paycheck mailer will allow you to do that. Everything that I've spoken of today is in a comprehensive employer toolkit All of this can be found on the employer page of the paid leave website. You scroll down to the bottom and it's all available there in English and in Spanish. You can reach us at our Contact Us portal, which is on the very first page of our site. We do not have a call center. We get that question quite frequently because call centers cost millions of dollars, and that is not how we are spending resources at the Paid Leave Authority. So we do have support from United Way. If you submit a question, someone will call you back and will answer your question, usually within 24 to 48 hours. We also have frequently asked questions and helpful videos on our site that are available for your use and for sharing. So thank you. I'm going to stop sharing my screen. Come back on video. And thank you for your patience while I try to manage the ambient noise in our neighborhood.
Hey, Andrea, thank you so much.
Hi.
We don't have any questions at the moment.
Okay.
For any questions that you have, please feel free to submit those through the Q&A. We would love to answer those live for you. So for the moment, I'm going to roll this over to Bill.
Yes, you went by rather quickly, Andrea, on the slide for the benefits. I wonder if you could just recap that.
Sure.
That was a quick, it was here and then gone. It suddenly disappeared.
Sorry about that. I'm actually going to, if you will indulge me, I'm actually going to try to go into another presentation and find a slide that gives an example of it. So if you just give me a moment, I will try to do that and I'll come back and share it if I locate it. Let's see. It is, oh, here we go. All right. It is a little tough to see if you don't, it's tough to follow, I should say. Let me go back. Yeah, here it is. All right. So can you see that?
Yes.
All right. Going to. Let me just put it in slideshow mode so it's a little bigger and easier to see. Okay. So here's how this formula works. It's in two parts. If a person makes less than or equal to the minimum wage multiplied by 40, and right now our current minimum wage is $12 an hour, then that person receives 95% of their weekly benefit. So in this example, Mike makes $375 a week, which is less than 40 times the minimum wage. So he then receives $356.25, which is 95% of his weekly earnings. That part's pretty clear, pretty simple. What gets more complex is when you earn more than the minimum wage multiplied times 40. So Deborah earns considerably more than the 480. She earns $700 a week. She's contributing $3.50 to the Paid Leave Authority Trust Fund. The way that this works is this. She, as at a base, receives the $480. Then she gets 60% of the difference between what she makes and the $480, which is not clear in the way that the statute is written. But in plain language, this is what she gets. She gets the $612. So what we first do is take her weekly wages and we subtract the minimum wage multiplied times 40. And that gives us a number of $220. She gets 60% of the $220. And we add that to the minimum wage. And we know that then to the minimum wage times 40, and then that makes her weekly benefit $612. That's how it actually works in practice. So if you were to read the statute, it is incredibly complicated and convoluted. But what it really means is that everyone starts at the 480. If you make less than the minimum wage, you get 95% of that. If you make more than that, then you get 60% of the difference between what you make and the 480. And that's how you get the number of your weekly paid benefit. Would you like me to leave this up for a little while longer?
That's okay. Yep.
Okay.
And I know, Amber, that I can see some questions coming in. Do you want to field them, Amber?
Okay.
Sure, I'd be happy to. So our first is there a minimum threshold to take the family paid leave out of the FICA wages?
Mm-hmm.
And she's asking because she has a client that uses QuickBooks and it took out the family paid medical leave automatically for their employees, besides one employee that made a lot less than others.
Okay. I'm just reading the question again so I can understand that. Is there a minimum threshold to take out the FICA wages? No, it's the 0.5%. So there isn't a minimum threshold. It's whatever that calculation is. QuickBooks, which is owned by Intuit, I think automatically provided, they didn't automatically provide, but they provided a patch in, I think it was November or December, that should have automatically calculated what that 0.5% is based on the FICA wages. So you're saying that you had, it took out the paid family automatically for the employees besides one employee that made a lot less. I hope that makes sense. Is the question then, is it a minimum threshold of earnings? If that's the question, then no, there is not a minimum threshold of earnings. And we do hear this quite frequently from student workers, per diem workers. Really isn't. It is 0.5% of whatever that particular person is making. Okay. So for the Deborah example, shouldn't the minimum wage be 40 times multiplied? No, it is not. I know we get this question a lot. It is not 40 times the 95. And we actually went back to to those that drafted the legislation, because we at the Paid Leave Authority had the exact same question, because that's how you would read it, and that is not how it's to be interpreted. It's a great question, great catch. We asked the same thing, and the answer is no.
Okay, thank you.
Okay.
We have one over in the chat as well. If an employer has a short-term disability program and an employee goes out on leave, should the employer wait to hear from the Paid Leave Authority with the amount that the employee is eligible for from the paid leave program before processing payment under emergent ER, I'm guessing is emergency short-term disability?
Mm. Oh. It is if you have been sitting in our claims administration meetings, because we were just posing the same question this morning. As a matter of fact, we were having this question about the how to coordinate the benefits with short-term disability. And I would say generally the answer is yes, that if you have an employee that is applying for short-term disability and also applying for benefits from the Paid Leave Authority, it might make sense to get in touch with the authority and let us know that that's happening. And we too will also be in touch with the employer so that those benefits can be coordinated, because it's important for us to be able to do that. We don't want employees to obviously be without income, but we certainly don't want them to get more than the 100%, because the statute was not intended to do that. So to the extent that we can coordinate those, that would be very, very helpful. Yes. So where it's practical and feasible, that's really what we came up with this morning, with the opportunity to provide some more guidance around that.
Okay. And also there's another, is the cap for the salary above the minimum wage?
No, so the salary cap is always the Social Security contribution rate. So it's always the 142.8 for right now, and it tends to go up every year.
Okay. And if an employee received Connecticut paid leave payment from January to March for 12 weeks, when would he or she become eligible for payment again?
Not until January of the following year. If they've exhausted all their leave in the first quarter, then they're not eligible again. But here's an important caveat. They might be eligible, depending on the reason that they took leave, for federal FMLA. So let's say that they took leave for their own serious health condition in January through March of 2022. But then later on in the year, they need to take family caregiver, they need to take military caregiver leave because someone in their spouse or their son or daughter was injured during active duty. They would still be eligible to take that leave under the Family and Medical Leave Act for federal, but they would have exhausted their eligibility under the state.
Okay. And are there any visa restrictions for the eligibility, because this particular individual has employees who are non-citizens?
Okay. So the statute does not speak directly to a person's citizenship and eligibility. It only speaks to employment in the state of Connecticut. But with that said, a person has to be able to prove that they have earned their wages in the state, and they have to have a legitimate form of proof of wages. So we're not taking, letters from employers. You have to have a W-2 or some other appropriate form of documentation that you have been paid legally for your work.
Okay. I have another question. We are currently withholding and contributing to the paid family medical leave. Say if none of our employees are eligible and they did not use the benefit, what happens to the funds collected?
Yeah, the funds collected remain in the trust fund. We often don't refer to ourselves by our full name, but it's the Connecticut Paid Family and Medical Leave Insurance Authority. It's insurance. So there will be people who will be paying into this fund who may never access benefits. And that is, we all know that is the nature of insurance. That is essentially how it works. It works not only that way in our state, but in every other state that has paid family and medical leave. But it's one of the reasons why, however, the threshold for participation, the wage threshold is so low, is so that there's a lesser possibility that people who would be contributing would lose the opportunity to participate. So there was actually a great deal of thought into that, given to that 2325 number, because it is the number that was determined through a lot of different means, that people who would be contributing, even at the minimal amount, would be earning that over time. Like kids who are students and per diem workers and others who might be contributing, but maybe earn enough over those 5 quarters, over that highest quarter of those 5 quarters, to actually be able to participate in the plan and have benefits payable to them.
Great. Thank you so much, Andrea. Again, if anybody has any questions, please feel free to submit this using the Q&A or chat, whichever is easier for you. We're kind of toggling between the two right now. But that does conclude our questions for the moment. Bill?
Okay.
Yep.
Andrea?
Just a final question, Andrea. There's some leniency in reporting, certainly for the first quarter, and
Sure.
you'll see an infusion of cash into the trust fund
That's right.
this month and then going forward. But tell us, what are the penalties, for those that are simply unaware? We're doing our best as chambers across the state. You certainly are. Outreach is, fundamental to your mission. But the companies that are clueless, the small businesses in particular, what are the penalties?
Yeah. So we're really, there are penalties, and the penalty primarily is that if the employer is not withholding and has failed to do so after significant efforts, the employer themselves will be responsible for making those contributions to the employee trust fund, and they will not be able to go back to their employees and collect that money retroactively at all. That's the primary penalty. We do, under the statute, have the authority to impose additional penalties, but really in this first year, that's not really our focus. We know it's been a difficult time, and no one could have anticipated the circumstances under which people are trying to keep their businesses afloat and maintain their employees. So we're not in a punitive state of mind at the Paid Leave Authority, which is why we're spending as much time as we possibly can doing outreach. If you are having trouble, and here's an example. I live in a small town outside of Hartford, and I gave a webinar to our Chamber of Commerce, and there were some people in there who were small businesses that had just learned about it the day that the webinar was being given.
Sure.
So the question is, well, what do I do? What you do is you start collecting that 0.5 of 1% right now, and if you need to catch up, use that catch-up period, that additional 1%, which you can use up through the end of June. And if you need more time than that, based on your calculations from January to June, then get in touch with us. But please don't panic. This is what we're telling people. Do not panic. Begin collecting. Submit what you've already collected. Talk with us. We can work through it with you and give you more time if that's what you absolutely need in order to make up those contributions. We don't want you to find yourself in a position where you as the business will be responsible for that. That's not the goal here.
Great. All right. We will end on that. I want to thank you, Andrea. Thank you, Amber, for fielding the questions. Thank you to our audience for your very thoughtful questions. As Amber pointed out, the session was recorded, and we would like, Amber, if you could send the link to us. We will post it next Tuesday as part of our weekly newsletter, GVCC BizLink, or you can call us and we will send you the link directly. Those impacted by our focus right now too, as a chamber, and is on getting information out about some of the federal resources, the shuttered venue Fund and the Restaurant Revitalization Fund. More details to those of the restaurateurs and banquet facilities and caterers that may be on the call. Please give us a call as well. Andrea, thank you so much. Congratulations on your first year anniversary.
Thank you. And Bill, if I might just take a moment of privilege, if you don't mind, to thank all of your members for their extraordinary cooperation. It has been an unprecedented year, and we've had really so much support from businesses who have said, even if I don't agree, I'm going to go ahead and do this. And the response, the very positive response, has been very overwhelming. So we just want to express our gratitude at the Paid Leave Authority for every business that has stepped forward and has been compliant with the law. We really do appreciate it.
That's terrific. All right. Thank you all, and wish you all a good day.
Yeah. Thank you,
Andrea.
Thank you.
Bye.
Have a great day. Bye.
Bye-bye.